Okay. Hopefully this is working and you guys can hear me. Well, there's nobody here to hear me yet. But I went back to StreamYard. I have some time left on StreamYard this month. And I really hate OBS, so I went back to StreamYard. Okay, let's get started.
Previously talked about before.
Well, the mugshot. All right. So I'm making a note that we have to have a Richardson hearing on that issue then.
And also just to, for scheduling purposes, at some point, hopefully before, right at lunch, I would like to have a discussion about whether the court would allow the state to introduce evidence from Dr. Broder that we had previously talked about before. I just wanted to get a ruling from the court so I know whether to get him here or not.
Okay. I don't know what evidence it is, so I'll just wait for you to bring it up.
Okay.
Defense, any issues before we resume?
No, sir.
All right. State, you ready?
Yes.
All right. You said ready.
Yes, sir.
All right, just want to make sure. Are you feeling all right?
Yeah, picked up a little cold, but I'm good.
Same here. So I understand. Okay.
Okay, because I was confused, I forgot to look it up. But a Richardson hearing, if there is reason to believe that an opposing party has failed to comply with their discovery obligations or has withheld evidence, they can request what is known as a Richardson hearing. The purpose of this hearing is to determine whether there has been a violation of the discovery rules, and if so, to determine an appropriate remedy. So it's a discovery hearing. So I guess it's similar to Brady. Brady is when evidence is not turned over to the defense that can prove, that can exonerate the defendant. I think that's the difference. That in Brady, it's evidence that can exonerate the defendant or help the defendant's case. With Richardson, it's just when discovery has been withheld, I believe. I will find out about that, though, because I'm not 100% sure.
All right, you all can have a seat. Welcome back, everybody. Good morning. I don't know who had car trouble, but I hope everything worked out and you've had time to kind of calm down from that. So we're going to get started. As when we left on Friday, the state was presenting the defense was presenting its case. I do need to ask you, though, before we get started, because we just had a couple of days off, did anybody discuss the case amongst yourselves in any way? Did anybody discuss the case with anyone outside of this jury? Did anyone do any research or watch any coverage at all about the people, places, things, or legal topics we've heard anything about?
No, sir.
All right, everybody says no. Mr. Taylor, call your next witness.
Thank you, Your Honor. The defense calls Bruce Ferris.
Yay! Mr. Ferris gets to testify.
Certainly.
Raise your right hand and be sworn in.
Do you solemnly swear or affirm the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I do. Thank you. Morning, Judge.
Morning, sir. My name is Judge White. I'm going to be presiding over this case. Just have a seat, make yourself comfortable in that chair. Get yourself about 12 to 15 inches from that microphone. It's pointed straight up, but it does adjust down, left, right, up, down, whatever you need. And you just speak directly, a loud, clear voice into the microphone. It should pick up everything.
Okay, I will.
Good morning.
Good morning.
Will you tell us your full name, spell your last name, please?
Bruce Eric Ferris, last name Ferris.
Mr. Ferris, what type of work do you do?
I'm a licensed mental health counselor.
And how long have you held that position?
I've been doing that for 14 years. I've counseled individuals I just recently counted 1,000 clients, not including group work I've done. I also am a consultant in domestic violence and testify as an expert court witness in domestic violence.
Let's talk about your education for a minute.
Okay.
Please enlighten us.
I have a Bachelor of Science degree in civil engineering. I graduated from the Police Academy in Gainesville, Florida, and I have a master's degree in mental health counseling.
And do you have any specialized education or training in a specific field?
Yes. Been to a lot of training seminars and certifications and various conferences. In my curriculum vitae, I'll call it a CV, my resume. There's about 100 items listed of trainings that I've been to over the years.
For what specific field?
In domestic violence and mental health and trauma to children and trauma in general. And I could go on, but that's the general focus of all my work.
Let's talk about your work experience for a moment.
Oh, okay.
Tell us about it, please.
So as a counselor now, my day is spent seeing individual clients. I specialize, like I mentioned, in domestic violence victimization, both men and women. I also see generalized mental health issues and typical things that a counselor would do, but I have a focus on domestic violence and family problems. I also counsel adolescent boys, most of which are going through the foster care system or adoption or divorce of their parents, etc.
All right, and what position did you hold prior to that?
I was a police officer in Gainesville, Florida for 20 years. I graduated the police academy in 1993, got sworn in 94. I retired in 2013. The last 10 years of that career, I was a detective, uniquely running. I was the lead detective of what's called the Domestic Violence Unit of the Investigations Bureau at the Gainesville Police Department. Over the course of that time when I retired, I looked back and did a little search, and I had arrested or filed charges or got warrants on 500 different abusers over those years.
Mr. Ferris, give us an idea of your professional credentials. Likely.
Sure. I have I'm licensed with the state of Florida, like I mentioned, as an LMHC or licensed mental health counselor. I have to keep up with education, et cetera, keep my license active. I'm certified as a Batters Intervention Program facilitator. In case anyone doesn't know it, Batters Intervention, which I'll refer to as BIP, is a 6-month class given to abusers who are found guilty or on probation or could be part of their injunction order. And it's a curriculum based upon the Duluth Power and Control Wheel, and it's a psychosexual type of not sexual. It's a type of therapy that involves some counseling and some ownership and learning. And also was a certified police officer, I mentioned. I also have certification as a domestic violence danger assessment and level of danger scoring system developed by Jackie Campbell out of John Hopkins University. And I also have a certification as adoption competency training, mental health professionals out of Rutgers University. I'll stop there.
And briefly, have you been the recipient of various awards and recognition?
Yeah, I have.
Just a brief idea.
Okay. The Alachua County Board of Commissioners had nominated me to Governor DeSantis to be part of the Children's Trust Fund of Alachua County. I received the 31st Annual Martha Barnes Award for outstanding achievement in the prevention of domestic violence against women. I had recognition for valuable contributions in what's called crisis intervention team. I train officers how to de-escalate confrontations with citizens. I did receive the 2010 Distinguished Victim Service Award for recognition of outstanding contributions to crime victims for National Crime Victims Week by a State Attorney General Pam Bondi awarded that to me, and Governor Scott at the time was there for the presentation. I'll stop there. There's a few more.
Have you been recognized as an expert on domestic violence in various courts of the state of Florida?
He already said that.
I have.
Approximately how many?
So I've been involved in 60-some cases as either consultant or expert witness. 50 of those I've been recognized by the judiciary as an expert in domestic violence, mental health, batters.
Yeah, I got 7 hours left. I'm upset with OPS. It doesn't like me. I don't like it. So I'm going to use my 7 hours I have left of StreamYard.
Intervention effects of DV on children.
All right, and when you say you've appeared before approximately 60 times as an expert witness, was it for any particular side in a dispute? That is to say, for example, in a criminal case, was it always for the prosecution, always for the defense?
But both. I worked for the state attorney's office and worked for defense, and a majority of my cases have been in civil court, though I have worked in criminal court also.
Would you, Mr. Ferris, tell the ladies and gentlemen of the jury what another definition of domestic violence is?
Well, so there's the criminal statutes of domestic violence, which are typically, we all know it's battery, ag battery, assault, ag assault, false imprisonment, sexual abuse, et cetera, person crimes involving a family or household member against each other. And that has another definition, that's spouses or family members living together, or it could be a couple that had a child together that have never lived together. Doesn't include, let's say, cousins who've never lived together and aren't intimate in any way. But through my experience, I've realized that there's a greater, that's umbrella, and that has to do with power and control. The abuser needs to control their victim. Now they'll use the criminal things, hitting, et cetera, all those things. But in a greater sense, there's also this, I referenced it earlier, the Duluth Power and Control Wheel that DCF's accepted for the VIP class. I'd like to explain the Power and Control Wheel, if that's
Yes.
okay.
In fact, with the court's permission, we can perhaps have the screen come down and the lights dim. Mr. Ferris, you have a laser point in front of you. A little star in red will provide you with
Okay. Judge, may I stand here and pay attention to the mic as I talk?
Any objection?
Okay. So as I mentioned, there's the criminal definition.
Was
And
there a question? Objection. Was there a question?
Go ahead. The question.
yes. What is it that's on the
Right.
screen?
so what
Mr. Ferris?
Okay, so-
Mr. Ferris,
yes,
would you please tell us what is on the screen?
I will. So this is what's referred to as the Duluth Power Control Wheel. And so there's physical violence and sexual violence. Those are the criminal things I talked about. And then there's these power and control aspects. And the nature of the power and control is repetitive. It's a way to get control. So up at, we'll call it 1 o'clock, using intimidation, making her afraid by using looks, actions, gestures, smashing things, destroying her property, abusing pets, and displaying weapons would be an aspect of intimidating your partner, again, to gain control. Using emotional abuse, putting her down, making her feel bad about herself, calling her names, making her think she's crazy, playing mind games, humiliating her, making her feel guilty. Then isolation, controlling what she does, who she sees and talks to, what she reads, where she goes, limiting her outside involvement, using jealousy to justify actions. Then a big one that I see often is minimizing, denying, and blaming, making light of the abuse, not taking her concern seriously, saying abuse didn't happen, making shifting responsibility for the behavior, saying she caused it. Another one is using children, making her feel guilty about the children, using the children to relay messages, using visitation to harass her, threatening to take the children away, male privilege, testing, treating her like a servant, making all the big decisions, acting like the master of the castle, being the one to define men's and women's roles, using economic abuse, preventing her from getting or keeping a job, making her ask for money, giving her an allowance, making her ask for money, not letting her know or have access to family income. And the last one is coercion and threats, making her carrying out threats to do something to hurt her, threatening to leave her, saying that he'll commit suicide, reporting her to the government, making her drop charges, making her do the legal things.
I have a couple questions I'd like to ask you about it. Wheel you
Sure.
demonstrated for. Is this something that you created?
No, this was created by, up in Duluth, Minnesota, there was a domestic violence advocacy group and also researchers, and they looked through police reports, they interviewed victims of domestic violence who come through the shelter, and through a period of time, they developed these 8 items and created the power and control wheel. This wheel is used around the country and actually internationally. Like I said, it's the base curriculum for the Batteries and Prevention Program class I talked about, and it's taught quite readily all across America and by use by domestic violence shelters, et cetera.
How long has this wheel, if you will, been in existence?
Yeah, probably, I'm guessing 30 years or so, could be a little more.
Are there any agencies within the state of Florida that predicate their decisions
Yeah.
upon the Duluth Power Wheel.
Yeah, the DCF accepted the power and control wheel for the curriculum for the VIP class.
That's the Florida Department of Children's and Family.
Families, they were the ones who were controlling the VIP class when it started up. Also, a lot of federal money, domestic, against women act, things like that have always promoted the power and control wheel bill, and also, giving out grants and education money.
Are the majority of abusers male or female?
Majority are male, but there's certainly a percentage that are female. I'd say it's at least 2/3 male at the least. And in my practice, I have male victims.
And what about on the other end, the victims of domestic violence? What's the percentage of males and female?
So again, there's some different statistics. Somewhere between 2/3 and 3/4 are men, and
Are men as victims of domestic violence?
2/3 to 3/4 abusers. So that on the other side of that, they're 1/3 to 25% male victims. And I just got a male victim this past week.
Okay, so look,
Okay, I'm done.
I want to make sure we're clear on this.
Sure.
You've told us that the percentage of abusers that are male is approximately 2/3, is that
At least
correct?
2/3. There's some statistics to make it actually higher.
Would you tell us, please, what percentage of domestic violence victims are female?
Somewhere between 2/3
Why-
to 3/4.
All right. Now, I want to
Why does
ask
it matter?
you if you would educate us, Mr. Ferris, about whether or not there are common characteristics that abusers share.
And I certainly can do that, Mr. Cheller. Can I make one closing statement about the Duluth wheel? and
Sure.
Power and control. So I think it needs to be said, maybe I didn't say it, that the whole idea of the use of the wheel is to get compliance by the abuser with their victim. So they're looking to control them, and either they use those criminal, the battery, or they use emotional abuse or intimidation, or use different techniques to try to control them. So the victim of domestic violence is placed with wanting to have the least harm to them. So they get into a compliance, I call it equilibrium type of status mode, where they seek to get along, to go along. They don't want to poke the bear. They don't want, they believe that this is certainly a danger to be involved with this person, their mate, their spouse, etc. So they comply. They get this compliance mode, and they can certainly appear to society that nothing's going on, but there actually is, and they're afraid to display that because of the retribution that might happen.
All right,
I'll go
so
on.
this wheel then is the product, if you will, of the science of domestic violence over the past 30
Right.
years.
And throughout my entire practice, the thousands of people that I've counseled and even the 500s I've arrested, I see this repetitively to be true.
All right. Now, would you please tell us,
Oh, I know. Thank you.
I need you to make sure you keep your voice up so that
Yes,
we
sir.
can hear you. Would you now tell us, Mr. Ferris, whether or not there are common characteristics that abusers share?
They can be anyone from all socio-economic stratas, and that's been my experience also. And I said, like I said earlier, predominance men, but also females.
What's the motivation for their behavior, abusers?
They want to control their partners. I find often an ownership type attitude. They want to control them.
How do they treat generally pets in the household?
Pets. So statistics have shown that abusers abuse pets well above average, more than average citizens would. And so I have two theories about that. One is that they're missing some empathy, or they tend to see things as objects. And so,
Objection, not responsive.
okay. Can I explain why they abuse pets?
Yes.
So if a pet is belonged to the female or their partner, the victim.
Sure, I'm gonna object.
Hey,
Can you approach, please?
yeah, I guess, yeah. It could. I'm just saying, she's not an abuser. He abused her. But yeah, I guess that makes sense. To get an all around clear view of what DV is. Yeah, so StreamYard, if it was $20 a month, not a problem. But it comes, I mean, it is $20 a month, but it's, you got to pay $240 up front. You know, there's other things that I want to get too. That you have to pay it all up front for a whole year. If I could pay monthly, I could get it.
Mr. Ferris, would you describe for us what the term coercive control means in a domestic violence
Sure.
relationship?
So coercive control, acts of aggression, assault, threats and harm, punish, frighten the victims. And that fits in with creating fear, and it fits in with this whole continuum of power and control, a pattern that is developed to control the victim.
Do offenders always behave violently, or does the abusive behavior happen in cycles?
They don't always act violently in what common term of a battery or an assault. It can be accomplished just by threats and fear. And in terms of a cycle, there can be a violent or emotionally abusive state, and then a honeymoon side of state, and then it cycles back. In the field, we talk of a model of kind of like rain and sunshine. And,
All right, and let me ask you, Mr. Ferris, does the victim always appear to be afraid or act like they are afraid of the offender?
Definitely not. Oftentimes the motivation is to hide the abuse from friends, family, law. There's lots of repercussions if it's disclosed. One could be fear that the oppressor, the abuser, the husband, the boyfriend, the wife, whoever is the abuser, will harm them. So they're very scared. The other is they might not even understand that they're victims of domestic violence. Quite often when I get clients, people don't know those definitions.
How common is it, Mr. Ferris, for a victim of domestic violence to smile?
Okay, I'm sorry. I know I keep pausing it, but I just want to say, for the amount of garbage I have talked about this defense attorney, I gotta say, he is doing a really good job at controlling this witness, because this witness likes to go off on a narrative, and he's doing a really good job at cutting off his narrative, because like he's interrupting him, but he's keeping him on track to what he wants to accentuate. And he's doing a really good job. I'm really enjoying this direct. I'll back it up just a touch.
Victims of domestic violence. Quite often when I get clients, people don't know those definitions.
How common is it, Mr. Ferris, for a victim of domestic violence to smile and act happy in the company of the abuser?
Very much so, and also in terms of even in public or with family.
Why?
Because they're afraid. They found this least resistance. They're trying to not poke the bear, as we'll say, or we all heard the term walking on eggshells. They're trying to avoid aggression by their partner because they've grown to believe that there's a threat here.
So would that be, could we characterize that as an appeasement?
Totally appeasement. It's something I see quite often. And if
what is the victim trying to accomplish by engaging in the appeasement behavior?
Not encourage him to be abusive to herself, or if there's children involved, she's putting up a front to again create a type of stasis or minimum amount of aggression, so they don't want to again poke the bear. They're afraid of the repercussions.
All right, now give us some insight into this, if you will. Does the introduction of a child change these dynamics at all?
Yes.
Tell us how and why, please.
Okay, so it definitely ups the ante. We'll speak.
I have the same objection at the bench.
I'll overrule on this one.
So yes, definitely, if someone is single and they're being abused, certainly they want to incur least amount of abuse. But when a child's involved, now they're concerned, and if they have a strong maternal instinct, now they're concerned about their own safety and their child's safety. And abusers will use a child as a manipulation tool to try to get at the victim. So the victim, that's even a further degree of way to pacify. Oftentimes women will stay in marriages because they want to protect the child, even though it's detrimental to themselves.
A couple of questions about abusers, if I may. How do they generally rate on the scale of ability to charm and deceive others?
Quite highly. Those 8 years I taught domestic violence crimes, I got to know quite a few, and some were individual therapy clients also. Many of them, I used to say, have the gift of gab. They were very personable, friendly. Not all of them, but a large percent definitely were very much the charmer. They'll hide the abuse, and they use it as a strategy to influence or control their victims.
Is there a pattern? Excuse me. Is there a pattern, Mr. Ferris, of denying, rationalizing, minimizing, or blaming the victim in these relationships?
And I can say a very high percentage, well, I don't know, over 90% I'd estimate of all my cases involve minimizing, denying, blaming. In fact, on the power and control wheel, I guess it's gone. It's one of the 8 categories is minimizing, denying, and blaming. And it's all a technique that she made me hit her. I didn't really do it. It wasn't that bad. They're always trying to minimize and talk their way out of their being abusive.
Would you explain to the ladies and gentlemen of the jury, Mr. Ferris, is there a particular time in these relationships when violence is most likely against the victim?
Yes. Very much. The most dangerous time statistically is when a woman or a victim of domestic violence is leaving their abuser, and if the abuser is there. There's a high fatality rate, high incident of danger to them. I've been trained in this in my evaluation with John Hopkins' work. This is a really dangerous time. As advocates for domestic violence, we oftentimes have safety plans. Those plans, part of those plans, you never leave.
All right. I'd like to ask you, Mr. Ferris, if I may, a couple of hypothetical questions
Certainly.
involving the hypothetical abuser and a hypothetical victim. First, I'd like you to tell me, would the following acts be consistent with an abuser? And allow me to finish, and then you give your opinion.
I'm going to object to that.
All right. Do you want to approach?
Yes.
Yeah, they were. Thought I muted myself. Yeah, they were moving to co-parent. But they weren't going to be living together. And I think one of the things that upset him that day was she wanted to pack her things last in the U-Haul so they could be taken off the U-Haul first and be put in her house, and then his things could be taken to wherever he was going to live. I think he wanted to like mix them up in the truck and I'll put them in her house. And like, I think he was trying. Now, this is speculation on my part. They did mention it in the trial that was one of the issues that day. And I think he was trying to wiggle his way into staying with her because he didn't want to separate. Yeah, like, you know, some of them are like, if I can't have you, nobody can have you. So then when they go to separate, that's when it gets more violent. Because then you've left, and some of them will actually hunt you down and kill you for leaving. Because they say, if I can't have you, nobody can have you. Which is stupid. Because if you love that person, why are you going to kill them? That makes no sense. But abusing the person you love makes no sense either. So there's no logical explanation for abuse. Yeah, like, yeah, they were moving together to co-parent, but they weren't together as a couple anymore. This was kind of like the end of their possibility of being a couple. And it did come out that she was dating somebody else. But of course, she wasn't staying with this guy because they were moving. This whole situation is crazy.
So, Mr. Ferris, I'm going to give you a series of hypotheticals, and I'd like you to tell us if it's consistent with abuse.
Yes, sir.
Shooting a gun in the kitchen of a home in an effort to intimidate the victim to stop speaking. Throwing the loaded gun at the victim.
That's not a hypothetical, because that
Cruelty to
happened.
pets. Punching a dog in the face hard enough to knock the dog unconscious. Throwing a cat down the steps. Placing a tracker on the victim's car, an illegal tracker. Throwing things, breaking things, yelling, screaming, belittling, cursing, humiliating. Declaring such statements as rid the earth, being in a murderous mood, kill all the bad people, take them out, being caught at night, peering into windows of the victim's home, violating a no contact order by sending a package, driving from South Carolina to Florida to be able to follow the victim, suicidal
Who punches a
threats
dog?
if the victim
I mean,
leaves,
come on.
more than 30 years age difference, and finally, prior marital history whereby the prior wife explains how she was beat up on the honeymoon. Would that be consistent with abuse?
Absolutely. And not only absolutely, but those are checklist points right off the Duluth Power and Control wheel, and right off my experience, they're stereotypical abuse techniques.
All right, and now my last question for you, Mr. Ferris, is I'm going to give you a
Apparently won the
hypothetical.
objection.
You tell me if this would be consistent with someone who suffers from abuse. Sending texts that are conciliatory with friendly emojis, accompanying the abuser during child time sharing ventures, acting deferential and subservient in joint therapy sessions, but decisively different in individual sessions, fearful of the abuser finding out the victim described him as controlling, manipulative, and abusive, and being exposed to threats, intimidation, pushing, holding down, humiliating, cursing. Would that be consistent with a victim of domestic violence?
Without a doubt. These are, again, techniques of compliance, not wanting to poke the bear, walking on eggshells, trying to minimize harm to themselves and their children. They'll put up a front. They don't want anyone to know, and they don't want their abuser to be angry by them disclosing. So
I don't think he's testifying technically. I think he is just asking, because all the stuff that he said has come out in court. So I think he's just asking, his expert opinion is the actions that, I mean, he said it was a hypothetical, but it's not a hypothetical, because it's the actions that Doug did and it's the actions that Ashley did. And he's asking if Doug's actions were consistent with DV and Ashley's was consistent with a victim of DV. And who was that just came in the courtroom? The blonde girl? Oh, thank you. That is Eva Benefield. That is Doug's daughter. Nope, it's not doing it.
yes,
Lastly, one other factor I neglected to mention, would a video of the abuser and the
Spacebar's not
abused at a
working.
restaurant with the child
My keyboard's weird,
and
though.
another adult, whereby they are all acting happy, be consistent as well?
well, certainly if you're asking, they're acting happy, is she still a victim of domestic violence? Definitely. And it also fits with this whole idea of appeasement. We have to remember that the domestic violence comes in layers through the years of events. So one incident.
Judge, I'm going to object to non-responsive.
So that behavior isn't just a spot image right then. What's going on inside her? Why is she acting that way? That's what I would ask clients. That's what we're looking for. And if it's truly a victim of domestic violence, she'll be in this appeasement mode to try to please him and not disclose the abuse to get along sort of description.
Oh, okay. It works when YouTube's the active window. And the left and right buttons work when YouTube's the active window. Okay. I'm much more comfortable.
My final question as it
With
relates
StreamYard.
in general to domestic violence. Assume, hypothetically, there were several violent or semi-violent acts of domestic violence, and then there was a break in the chain of events for, let's say, as much as a year or two, and then it started up again. Does the victim remember, and is the victim affected by the earlier acts of abuse?
Without a doubt. I've got clients who tell me about
Sustained.
Yeah, just
so yes, definitely they don't forget the abuse that's occurred to them, trauma lasting. Adults remember childhood trauma, let alone something from several years ago. Like I say, layers of impacts of behavior.
Thank you very much. No further questions from Mr. Barrett.
State, Cross.
Thank you, Judge.
Oh, this is going to be painful.
Good morning, Mr. Ferris.
Good morning.
Mr. I want to ask you give you some examples and ask you if this is consistent with a victim mentality.
Sure.
Minimizing the abuse.
Now you're asking me if the victim would minimize?
Yes. Like what I mean by that, and maybe I said it wrong, is like covering or taking blame for the abuse, covering for the abuser, taking blame,
Yes,
making excuses for him
definitely.
or her, I guess, but not reporting the abuse,
Right.
dropping charges if they were filed.
Yep.
Not standing up for themselves
Yes.
and not leaving.
Yes.
Okay. I'm going to put that wheel back up and I want to talk to you about the pie sections each.
Sure.
Sorry. While she's fixing it, and I know you're familiar, and do you have a copy in
I
front
do.
of you?
I
do too.
I want
do
right
too.
in front of me.
And so I want to talk first about the use of intimidation. Would you agree that if somebody, this says making her afraid by using looks, actions, gestures, smashing things, destroying things, her property. We talked about a break. If those things weren't occurring for years, would you, but had allegedly occurred prior to that, would you still consider that part of this dynamic?
Yes.
If it's been a distance in time?
Yeah, I think the distance can be totally irrelevant.
And there's a section on here about the economic abuse.
Mm-hmm.
Would you find that if a hypothetical victim was living on her own for several years, had no monetary dependence on the alleged abuser, and lived in her own home in another state for part of that, and there was no monetary connection, that would not apply to a relationship?
Could you restate the question?
So if in this wheel,
Right.
hypothetically, we're not talking just about using economic abuse.
Right.
Would you agree, would you say it still applies if the victim was living on her own for several years with family and independently sufficient economically?
Mm-hmm.
No financial dependence on
Mm-hmm.
the other person. Would you agree with me that economic abuse would not apply to that relationship?
From the scenario you give me, it doesn't sound like it would apply.
And for isolation, would you agree that if it's the same facts, living on her own for several years with family, so I know it says isolated from family, I think, living on her own with family and having some periods of no contact for over a year, and then being back in contact, but living separately and having her own cell phone, having her own car, having her own home, would you agree with me that that's not a situation where there was isolation?
Well, you have to remember under the isolation also comes jealousy and justifying actions. So in terms of isolating, not letting their partner or the victim go to work or see family, in that sense, what you're saying is true. But a component of isolation could also be extreme jealousy, possession, your mind, those sort of things.
And I didn't add those facts. You're adding those facts, right?
Well, under the power and control world, the last item, I don't know if you actually mentioned it, using jealousy to justify actions.
And if that was not a factor, that's not a factor.
Then isolation component may not be part of that, component for the scenario we're looking at, the couple we're looking at.
And why do you say may not? What part of that would apply?
Well, would not be.
Okay, thank you. Using the children.
Mhm.
If the hypothetical victim had custody of the child and attempted to terminate parental rights, and the hypothetical abuser had to seek court intervention to get the child,
Right.
would that be a factor in your consideration of whether children were being used? If she had sole control of the child.
So you're asking me if I could just reframe that the alleged abuser is not he's not using child against their alleged victim, then they're not necessarily guilty of using the children.
I'm not asking if it's guilty. I'm just asking if that would apply. We talked about how these things apply.
It may not apply. It would not apply. But I think if I could mention, you're missing the point of the power control wheel. This is about pattern of behavior.
I'm not missing
Okay.
it. I'm just asking hypothetical
Okay.
questions. How about the using a male privilege? If that hypothetical abuser was not having any control over her big decisions or did not live with her, so was not being the master of the castle, was not treating her like a servant because they lived separately, and was not defining their roles, in fact, was offering to purchase things, get her anything she needed, those kind of things. Would you agree with me if those were the facts of a relationship, male privilege would not apply?
No, I wouldn't agree with you.
Okay, can you elaborate?
Yeah, the men's roles. And when you say purchasing things, I would want to look into what is that a concept of what the role is. I'm the man. I purchase things. I control things for you. I decide what to get, et cetera. So that could be a male privilege issue.
Okay, and I understand that, and that was a poor fact scenario in mind. I think it kind of goes with the economic abuse, and what I should have asked is if she's asking for, can you stop and get me boxes, or can you stop and get me tape, or can you stop and get me something else? And he is, yes, of course, and he does. That's what I'm talking about, not him telling her what she may have.
So in terms of him buying things for her that she's asking for, I wouldn't consider that to be domestic violence.
Okay, you would not.
No.
Okay. And so that's, other than that caveat, then male privilege wouldn't necessarily apply to the cycle that we're in, under my facts.
The facts are not complete enough for me to come to the conclusion.
Okay. How about minimizing, denying, and blaming? What you said that was present in 90% of the cases.
Quite a bit, yes.
Right.
Mhm.
I think you said 90.
I did.
What if the hypothetical abuser says, I was wrong. I lost control. I shouldn't have done those things, and never says it was your fault you did those things? Would you then feel like
No,
that's
abuser.
not minimizing, denying, and blaming?
No, I wouldn't agree with that, because it could be that part of the strategy of minimizing could be that I'm sorry I didn't do it. That could just be minimizing.
I'm sorry I didn't do it. I'm sorry I did it.
Right.
That's part of
That's
minimizing?
Yes.
Well, certainly not denying or blaming, right?
I would need more definitive
I guess
facts.
I need an explanation on if somebody takes responsibility for accusations against them, how
Right.
that is minimizing. Just to say, yes, you are correct, and I'm sorry.
It could be a way to dialogue or to minimize what occurred by accepting blame for it, and that could be part of their scenario.
Could it also be the opposite?
Yes,
That person
it could
is
be.
taking credit, is taking responsibility for their actions.
Right. Certainly doesn't deny that it happened. That's for sure.
Right.
Okay.
And no blame being set forward if they say it's my fault.
Well, just because someone apologizes doesn't mean they weren't abusive.
I'm just talking about the factors on this wheel
Right.
and whether or not if somebody under my hypothetical admits to responsibility for the accused abuse and apologizes for that, whether or not you would consider that denying and blaming.
I would need more information on the relationship in the scenario to decide that.
Is there a scenario? Okay. How about using emotional abuse? If there's no accusations of any name calling or telling her what to wear, this hypothetical victim, in fact, she's comfortable enough to wear a sports bra and shorts around him. There's no displaying weapons. I'm sorry, I'm sorry, looking at the wrong one. No evidence in their relationship of playing mind games or humiliating her or making her feel bad about herself. Would you agree with me that that might not be a factor?
Well, you gave me a discrete list, but emotional abuse also includes name calling,
Okay.
putting someone down, affecting them emotionally.
Mr. Fair, where you with me that a relationship might not include emotional abuse? Because I don't know how to give you enough factors for you to say no,
Yeah,
it may not.
yeah, I can't help you with that. I'm not asking the questions.
Oh, I was asking you one.
I know I'm not. You are.
Would you take into account, based on with these factors such as emotional abuse, economic abuse, male privilege, using children, all of these, if the alleged victim, but let me give you a scenario. She does not live with him. She's actually in another relationship, potentially engaged to a new man.
Okay.
She
She
wasn't.
tells him that she does not want to be with him,
Okay.
and she plans to move away without him. Would those be factors that you would have to take into account when deciding if that relationship fit this power and control?
Well, that would be factors of the relationship, but I haven't heard you say anything about what their history is, what trauma she's experienced, what's going on with children in their lives, all sorts of other dimensions of their relationship.
I guess, so is there no scenario where there can be abuse in a relationship and then there no longer is abuse, where they are no longer in this wheel? Because the way you're answering your questions, that's the impression I'm getting.
So there, I have come across situations where there's an emotional abuse or a physical abuse, but it's not a pattern or behavior. It doesn't go on over a period of time in an attempt to control someone. So if I may, if someone pushes down their girlfriend on a night out and he gets arrested for domestic violence because they live together, it's a battery, that's domestic violence. But that's it. She's not appeasing, she's not put an emotion, the whole power control dynamic isn't happening. That is domestic violence under criminal law, but it isn't domestic violence in the sense of a pattern or behavior to try to get the appeasement or this sort of consensus out of a victim where they're afraid to poke the bear, all the things I've already talked about. So if that answers your question.
It didn't. Is it your testimony that once a relationship has these power and control aspects, that is forever, even if there's no continued allegations of abuse for years, no continued allegations of abuse, no continued allegations of emotional abuse, never any allegations of sexual abuse? The parties are living apart. They're independently, I keep saying independently wealthy, that's not what I mean, economically independent. They are, the female is telling him she doesn't want to be with him and has moved on to a new relationship. Is there no scenario, in your opinion, where people can get off this power and control wheel, even if they were on it at some point in their relationship?
I think it's possible, but it's not likely, and it's not the typical thing that I see. Usually there's still a dynamic of emotional abuse.
So even under my facts,
yes,
with no allegations of emotional abuse in years,
no.
It's your opinion that not good enough, they're still on this power control?
Well, I can speak from my critical learning and studying this, and also my practice, and I have custody issue couples where they're domestic violence, and 10 years later, there's still abuse taking place, even though they're remarried and don't live together. So by example, I see continued abuse. Could there be a couple that don't? I'll say it's possible.
Thank you. I don't have anything else.
Redirect.
Nothing further, Your Honor.
Can this witness be released?
Yes, sir.
Yes.
Sir, you are released from your subpoena. You're free to go.
Thank you for all your help.
I wish he'd asked him. He may have. I might have missed it. Not every single one of those things has to be present for, right?
All right, Mr. Taylor, call your next witness.
Gina Torsia, Your Honor.
Judge, I think we're gonna have to throw this whoever comes in first.
I'm so sick of trials with bazillion sidebars. Like the one guy I was telling you guys, that controlling ex that I had, we didn't live together. So, I wasn't isolated. There wasn't a financial component, but yes, I was still in a controlled, abusive relationship. So there was no financial, there was no isolation. Thank God there was no kids. But there was definitely power.
Defense corporation Gina
Men don't suck.
You solemnly swear or affirm the testimony you're about
Some
to give
men
will be the
suck
truth, the
and
whole
some
truth,
women suck.
I do.
It's not an
as she's sitting down,
absolute.
attorneys come back one more time.
Really?
Hello, ma'am.
Good morning, Your Honor. How are you?
Go ahead and have a seat. My name is Judge White. I'm presiding over this case. Just make yourself comfortable in that chair. You want to be about 12 to 15 inches from that microphone. You can adjust it up, down, left, right, however you need. If you just speak in a loud, clear voice, we should hear you just fine.
Yes, Your Honor.
Good morning.
Good morning.
Would you tell us your full name, spell your last name, please?
Gina Torchia, Torchia.
Ms. Torchia, did you at one time work for an attorney by the name of Stephanie Murphy?
Yes, sir.
Back in June of 2018, would
I
you
thought
have
we
been
cleared
employed
this up.
under Ms. Murphy's guidance?
Yes, sir.
Do you recall exchanging an email with Detective Gillum on June 5th, 2018?
Yes, sir.
Did you have an opportunity to review it?
Yes, sir.
I'm going to pass to you, Ms. Torchia, what I've marked as defendant's exhibit number 25. And ask you if you can identify it for us.
Yes, sir.
What is it?
It's an email from Detective Gillum.
And does it include a response from you? Or is it a response to your initial email to him?
It's a response from my initial email to him.
Okay, and is it a true and accurate copy of your email to him and Detective Gillum's response?
Yes, sir.
Move to introduce it into evidence at this point, Your Honor, Defense Exhibit 25.
Same objection?
Yes.
Oh.
All right,
Defendant Exhibit 25 will be received.
Ms. Torchia, did you on this day send Detective Gillum a copy of the South Carolina Domestic Violence Restraining Order?
No, because we were not aware of one.
Okay. Does he send you a copy of the order?
He does send me a copy of the order, but there was never an order entered into the Charleston County Clerk's or the Sheriff's Office.
Yeah.
So we had no proof of an order at the time.
Would you please read for us, Ms. Torchia, Detective Gillum's response to you on Tuesday, June 5th, 2018,
Gina,
6:19 p.m.?
I noticed something that you both need to be aware of, unless there's something I'm missing. If you read that section just before the judge's signature, it states the order will be in place 6 months of the day of the hearing, which was May.
Can you slow down just a little bit?
Oh, I'm so sorry. I'm a fast reader.
Okay,
Sorry about
slow
that.
down a little bit for us.
Evelyn Wood School, huh?
Where do you want me?
You're good.
Okay,
6 months of the date of the hearing.
which was May, November, which was May, November 3rd.
Ms. Torchia,
Yes,
I'm sorry. Would you start over, please?
yes, sir. Gina, I noticed something that you both need to be aware of, unless there's something I am missing.
What does that mean?
If you read that section just before the judge's signature, it states the order will be placed for
I don't even know what
6
that
months
means.
of the day of the hearing, which was May, November 3rd, not November 27th, and sets it to expire May 3rd, which would be 6 months from November 3rd. Again, it's not something I would have made a physical arrest on, but the SAO will at some point make a filing decision. If I am reading something wrong here, let me know.
Okay, we can agree that SAO would be state attorney.
Yes, sir.
So lastly, Ms. Torchia, this is Detective Gillum telling you that the order was in effect, the stay away order,
Objection.
as of November 3rd, 2017, correct?
Objection.
Sustained.
This is Detective Gillum explaining to you.
Objection asked and answered. Did you read the email?
Sustained.
Just a moment, Your Honor.
So what? Like the video's choppy? And like you're not seeing everything? Oh, okay. Because it looks fine from here.
Ms. Torsten, let me pass you what I've marked as defendant's exhibit 26.
Can I see it, please? Can I see it? Can we approach this?
Probably
So,
what I'm gonna have to do when I get my studio set up, if my stepdaughters will ever come get their crap out of my spare room, I'm gonna have a nice studio set up one day, and then I will get our internet provider to come set up the modem. I mean, our modem's in our living room now, but I think I'll have them come set up the modem so I can hardwire it in to the desktop so that my internet for streaming will be good all the time. No, not right now. I'm not. Now it's Wi-Fi. So when I get my because the modem is way in the other room and there's no way to move it without running a cable across the house. So when I get my studio set up, I'll be along the outside wall of the house and we can just run a cable somehow. It won't go across the whole house. We can run it outside or even move the modem into that other room and rewire it somehow. And then I can actually plug into the desktop and then I'll have a wired connection. So, but I don't know. I don't know when they're getting their stuff out of my house. It's been like 2 years they've been trying to get their stuff out of my house. Oh, there will still be movie posters. If you look back at my old videos, like my very first, they're probably crappy. I mean, not that my newer ones are any better, but my first ones I'm sure were worse. I've got a lot of movie posters up on those until we changed our bed and I took them down because I thought the headboard was going to be higher on the new bed. And then Travis wouldn't let me put them back up. He goes, I like the blank wall. I said, I don't like the blank wall. So I only put up smaller movie posters. I said, okay, we'll compromise.
So let me pass this to you. I want to see if this refreshes your recollection as to whether or not you sent a copy of the South Carolina order to Detective Gill.
Yes, sir. Yes, this is the order.
Yeah, without referring to it, my question is only, did you, in fact, now that your recollection has been refreshed, send a copy of the order to Detective Gill?
Yes, sir.
And then he responds to you a couple hours later with the email.
With yes, and there's also
No further questions, Your Honor. Thank you, Mr. Bush.
Any cross?
Can you finish your answer, please?
yes. There's also a predicament where Detective Gillum, there was no order entered into the clerk system in Charleston, and there was no order entered into the Charleston Sheriff's Office. So he had no bounds to make an arrest just based on this when it wasn't entered.
Sustained.
Ask to
further questions.
disregard, Your Honor.
Members of the jury, testimony regarding an opinion's witness about violation of criminal law is inappropriate, and you should disregard those last comments. Anything
No
else?
That's sufficient. Thank you, Judge.
Read a rep.
No.
Can the witness be released?
Yes.
Yes.
Thank you, Your Honor.
Thank you, ma'am. You're released from your subpoena.
Would you like to? Thank you.
Mr. Taylor.
All right, I wonder if we could publish the exhibit that.
Is it the same company that makes the insulated drink things? I guess it would have to be, right? If it's the same name. I don't know. Someone recommended this brand to me, and all I told my husband was I wanted a microphone. I didn't tell him what kind because he doesn't like his memory's really bad. I knew he wouldn't remember. And when I opened it, yeah, I would think it's a separate company. But when I opened it, I freaked out. I was like, oh my God, you got me a Yeti. Because I didn't even tell him what brand. He just went to Best Buy. He said, I have to go to Gainesville to get your birthday present or Christmas present. I was like, okay. Because we live way out in the sticks. I was like, why does he have to go to Gainesville? So I'm thinking about all the stores that Gainesville has stuff that he can't get here. You know, because we have a big, big Walmart store. Oh, okay. So, I'm like, okay, what store? Where is he going? What is in Gainesville that we don't have here that he could be getting me? And I had no idea. And he said, yeah. He asked them what the best mic was. You know, for a lower budget, what the best mic was. And he got the mic and the boom and everything. And I was like, you so good, honey. I'm so happy. So he supports my hobby and he wants me to be monetized so he can quit working. I keep telling him, yeah, I don't think that's going to happen anytime soon, honey. Just keep wishing and keep buying me new stuff. Next, I need a good camera. Well,
I think it's a great time for our mid-morning break. So I'm going to sit you out. Give about 10 minutes or so. Feel free to use the facilities. You can use your phones if you need to send or receive text.
But if he wrote something and asking him.
oh,
2019.
should have waited. Okay.
Seek to admit it as an exhibit or just testimony?
No, just testimony.
Phone calls, anything like that. Please don't begin any sort of deliberations or discussions amongst yourselves about the case. Don't discuss the case with anybody outside the jury. But don't do any research on the people, places, things, or legal topics. Y'all can have a seat. All right, so the issue is a police report that I haven't seen, but it's my understanding what it says is that Ms. Benefield went physically to the telephone reporting unit of the Manatee County Sheriff's Office. I'm going to summarize, you can correct me. With
Yeah, that's so far.
all right, so this isn't marked. Is it? Did you seek to admit it as an exhibit or just testimony?
No, just testimony.
All right, so you expect the testimony would be from a deputy with the sheriff's office that Ms. Benefield went to the telephone reporting unit. On December 6, 2019.
Phone call.
That Ms. Benefield wanted to document the fact that her estranged husband admitted in a text message that he placed a tracking device on her vehicle in the past. That she has observed him driving behind her on multiple occasions, which concerns her. That she wanted this information documented. She brought her vehicle to a local auto dealer, but a tracker could not be found. Due to the fact a tracking device was never observed on the vehicle, an information report was completed. All right, any objection?
The objection, Judge, is that anything contained in this report, which the nature of this report, according to it, is information. But anything contained in this report is hearsay, other than that Ms. Benefield physically appeared at TRU on December 6, 2019, because everything that Mr. Deputy Lindsay wrote down was told to him by Ms. Benefield. And so the state would object to his being able to testify to anything other than she appeared at TRU on that date, which seems irrelevant, if you remember.
Proponent, defense?
Yes, so it clearly goes to her state of mind at the time, and it also corroborates her defense. I do not plan to ask the deputy to read it. I'm going to ask him if he took a report from Ms. Benefield, what the date was, and whether or not it was her reporting about a tracker being placed on her vehicle. That's all.
And that's hearsay, in the state's opinion, Judge, because it's self-serving hearsay.
Yeah, but state
It's
of mind is
hearsay
an
and hearsay,
exception.
I think. But if he wrote something and asking him what he wrote in a report about somebody else told him, but it's at least one level.
All right, thank you both very much. The purported reason for the introduction of this testimony, according to the defense, is to show the defendant's state of mind and that it corroborates her defense. Both of those sound to me like the introduction of this report to the sheriff's office regarding a tracker is being offered for the truth of the matter asserted that a tracker was placed.
No.
That would obviously make this hearsay. It's the introduction of an out-of-court statement to prove the truth of the matter asserted. That being that a tracker was placed on her vehicle, thereby corroborating the testimony that has already been provided. My notes are that it's already been testified to that the tracker was placed on the defendant's vehicle. And my notes are that she testified, or it's been established, that the victim in this particular case admitted that he placed it on her vehicle.
Yes.
So that's already in. And I think I said this the other day, and it bears repeating. So this is self-serving hearsay. It's clearly excluded. I will just note a secondary reason would be the relevance of this report. The issue is not whether or not she reported it to the authorities. The issue is not whether it's true or it's not true. The case law is very clear on this. It's not relevant whether law enforcement believed her or didn't believe her. The purpose of allowing these prior bad acts, and I say prior bad acts instead of going into all the different ways that can be done, but in a self-defense case, once the defendant has established there was an overt act, prior incidents of violence and intimidation and threats can come into evidence. The case law is very clear. They may be true, they may not be true. The issue is, what did the defendant know on the day that the force was used? And so those prior acts of the specific incidences of prior bad acts or prior violence don't have to have happened to her. She just has to know about it. And the tracker issue, while not necessarily violent, certainly it's intimidating. And I allowed it. I don't remember if the state objected or not, but I allowed that in. The testimony is in. Whether she reported it to law enforcement is of no moment. Whether it's true or not, because
That's
put it this way,
true.
the tracker wasn't found, so it was just an information report. it doesn't matter if it was found or not.
Right.
It doesn't matter if this officer believed her or not. The issue
And it
is,
is
it's something
hearsay.
she's aware of. She testified to an overt act. It's already in evidence. So at this point, this is not marked. What was it? I don't even, who was the next person? What was his name or her name?
Lindsay.
That was Deputy Lindell.
Lindsay. Scott Lindsay.
Lindsay.
Scott. Top of the report.
Scott Lindsay, I'm sorry. Lindsey.
So, I mean, you could call him, but the substance of her walking in, him taking a report, again, none of that is relevant to the issue of her knowledge of prior incidents.
That's all I was calling it for, so. Yeah.
All right, I do want to give you all a break, though. I know we started at 9. It's about 10:30. I think it's reasonable to go ahead and take a break. So why don't you guys take 10 minutes?
Thank you, Judge.
Before we recess in 10 minutes.
I said camera should be my next expense, but actually I need a desk. If they come get their stuff, I need a desk. I want to set up a little area for Belle and have a Belle cam because I can't hold her like I've been doing. That's because it was storming, though. She wanted her mommy. Yeah, if I get another, I mean, this camera's pretty good, I think.
All right, welcome, have a seat. Welcome back, everybody. Hope you got to stretch a little bit. Maybe run a jogging place, warm up a little. So we've got
I look pretty good, don't I?
the defense going to call their next witness, but before
I
we
think
do
it's
that,
not
I
a
want to
bad
ask everybody
camera.
to begin deliberations amongst yourself. Speak with anybody outside the jury about the case or do any research on those topics we've talked about. Everybody says no. Mr. Taylor, call your next witness, please.
Thank you. Vincent Fizzicaro.
I mean, I'm not fishing for compliments or anything. I'm just saying it's not a bad camera.
Can you sum us for the testimony you're about to give will be the truth, the whole truth, and nothing but the truth?
I want to get a bookshelf, put up some posters and some art behind me and some neon
Make
lights.
yourself
And
comfortable in that chair. My name
I'm
is Judge
so
White. I'm
excited.
presiding over
I
the
can't
case.
wait.
You can adjust that microphone up, down, left, right as you need. Stay about 12 to 15 inches away. Speak in a loud, clear voice. It'll pick up everything.
Sounds good.
Good morning.
Morning.
Would you tell us your full name and spell your last name for us, please?
Vincent Vizzicaro, Bizzzacaro.
All right, Mr. Fizzicaro, I'd like you to try to keep your voice up if you could.
Will do.
What do you do for a living, sir?
I'm in real estate.
And where are you a realtor?
Lakewood Ranch, Bradenton, and Sarasota areas.
Do you have any particular specialty?
Residential homes in Lakewood Ranch.
How long have you been doing that?
About 8 years now.
I want to ask you whether or not back in 2018, you had occasion to deal with an individual by the name of Douglas Benefield.
Yes, I did.
Would you tell us the circumstances under which that relationship took place?
Yes, he contacted me looking for a home.
Hearsay.
I'll rule at this point.
Thank you, Judge. Contacted you looking for a home?
Looking for a home he was trying to acquire through a business that he said he owned in Lakewood Ranch.
All right. And back in 2018, Mr. Vizzicaro, did you use emails to communicate with him?
I did.
And did he communicate with you in the same fashion?
Yes, he did.
Were emails back then a normal and customary part of your business?
Very much so, yes.
Did you preserve the emails as they related to each client's files?
I do that, yes.
And were the emails under your care and custody?
Yes.
Mr. Fizzicaro, I'm going to pass to you what we've marked as defense exhibit number 27.
Can we approach them?
Yes.
Okay, I'm starting to think that the prosecutor is just a witch. Because it's like every witness before they even get good and started.
That's my responsibility. So if you could, close up your notes and leave here on your chair. And I'm going to excuse you back into the jury room for a couple of minutes. I will get you back out here as soon as I can. Don't begin deliberations. Don't talk with anybody outside the jury. And no research on any of the issues. Thank you. All right, y'all can have a seat. Mr. Isakara, what I'm going to do is at this moment, I need to do some research and speak with the attorneys. So I'm going to excuse you to the hallway. There's a thing called the rule of sequestration that has been requested by both parties. And that means that you cannot discuss your testimony or the questions asked of you with anyone else. You can't discuss other witnesses' testimony or what questions they were asked or testimony they gave while you report. Or do any research on the case, watch it, or anything else.
Understood.
We'll call you back as soon as we can.
Okay, thank you.
Thank you. All right, I'm just going to ask before I start doing my research, do you have any cases you want me to know about right now?
No, Your
All right,
Honor.
so let's, I'm sorry, go ahead.
We're traveling under the words in the statute, specifically 9803(6).
Understood. All right, so I'm thinking it's going to, I need about 10 minutes or so. So we're going to take a 10-minute recess, maybe 15-minute recess. I want to look this up as well because I want to find a case that gives me some direction.
Okay, yes, sir. Thank you.
Of course, that means you can too. Let me go back on the record.
Yes.
That one? Probably get in trouble for that. Electric Light Orchestra. Gosh, I hadn't heard that song in years. What happened? What I missed? Looking up that song, I missed something. Did they go to lunch? What did I miss?
All right, I'm just going to ask before I start doing my research, do you have any cases you want me to know about right now?
No, Your
All
Honor.
right, so let's, I'm sorry, go ahead.
We're traveling under the words in the statute, specifically 9803(6).
Understood. All right, so I'm thinking it's going to, I need about 10 minutes or so. So we're going to take a 10-minute recess, maybe 15-minute recess. I want to look this up as well because I want to find a case that gives me some direction.
Okay, yes, sir. Thank you.
Of course, that means you can too. Let me go back. All right, proponent, go ahead, sir.
Well, I think it's admissible. One is a business record, which we've already qualified. Business records traditionally contain hearsay. And under the statute, Your Honor, specifically subsection C, we got this email from the state. However, we then gave it back to the state in its isolated form. They have not filed any objection to it, so they've waived that objection according to the business records exception. We also believe that it shows Doug Benefield's state of mind, that he was in the process of buying a home directly behind Ashley Benefield's home during the time period when the South Carolina injunction was in full force and effect.
Ooh. Yeah, that's not cool.
All right, anything else, sir? State?
Judge, I found a case I would like to put on the record, Thomas v. State, 993 Southern 2nd, 105 from 2008. It is specifically addressing an email that was put in as a business record. I didn't have long to read this, but it was an email that was sent to an apartment complex manager of some sort. And it appears as though it was not qualifying as a business record. And additionally, the hearsay within the email was not admissible. There is a yellow flag, and I'm trying to look at it now.
He wouldn't. I mean, like, how would he know? How would he know that there was a restraining order and he couldn't be that close to her? He would have absolutely no way of knowing that. It's from another state. Well, I don't even think he wouldn't know that even if it was in the same state. Like, they don't send a flyer around all the real estate agents in the state saying these two people can't live that close together. The person that has the restraining order against them knows he's not supposed to move that close. I never even thought about that before. How? I don't want to overuse the word evil, but how disconcerting would that be if your abuser that you have a restraining order against moved? Now, it's been a long time since I lived there, but those houses, they're so close together. Literally. I mean, you can throw a rock and hit the house next door or the house behind you. These houses are right on top of each other. They are right on top of each other. This is where I lived. I don't know. I think Brian, you might remember because I think you made a comment on it. When I said when I was little that the kids down the street came over and played on my play set in the backyard. Yeah, they were like 2 houses down and they were like, "Oh, play set." And they just yeah. But like you can see into the windows of the people that live behind you and next to you, and they're that close. You could open your window and talk to the person in the next house. This is why I'm not comfortable living in the city anymore, because we moved when I was 12. We moved out here in the country
Did you review
where houses are required to be on 5 acres of
Thomas
land. I've
v.
never
State?
lived that close to anybody as an
Mr.
adult.
Taylor?
When I was a
Do
kid,
you want to make any
though,
argument on it?
they are right on top of each other.
So Thomas v. State is helpful. So 993 Southern 2nd, 105 First DCA. Although it was the state introducing the email against the defendant, the state sought to introduce an email that was prepared by an employee of the apartment complex where the victim lived and was murdered, regarding statements made by the victim that she had someone living with her that was not on the lease for a year and she wanted that person out. And obviously the state was introducing that to prove that that was the defendant and that the victim was trying to evict him, and that was part of the reason why he then murdered her. And the first DCA found that even if the email from the employee's side qualified as a business record. And I seem to, I don't see where they actually found and held that the email was a business record, which was my original question, but ultimately concluded that the statements that were made and then by the employee and then communicated through that business record, those statements were not, well, first they're hearsay, but they were not part of the records and the data compilations of the business itself. And that although hearsay may exist within exhibits that fall within an exception, such as business records, those hearsay statements must still qualify under a separate exception to the hearsay rule. And in this particular situation, if I'm understanding correctly, what the defense is asking is to introduce Defendant's Exhibit 27 through Mr. Vizzacaro as his business record that he keeps. But according to Thomas, and then they also cited a prior case of theirs, Van Sant v. State, VANZANT, 372 Southern 2nd 502, Florida 1st DCA 1979. Even if this qualifies as a business record, which again, I have not found a single case that says it does or doesn't, and I don't see in my review of Thomas where it says it is or isn't. But the statements of Mr. Benefield are being offered to prove the truth of the matter that he's looking to buy a house in Lakewood Ranch are hearsay without exception.
But the exception, Your Honor, is state of mind. It clearly shows Mr. Benefield, let's not forget what the defense is here. The court's allowed me now to bring in evidence of domestic violence. And here is Mr. Benefield, Judge White, negotiating with a realtor to buy the house directly behind the home where Ashley Benefield lives. And he's doing it at the time the South Carolina domestic violence injunction prohibits that. He would not be able to buy that house directly behind Ashley Benefield's home. It's like 200 feet away, 100 feet away. And it's a continued pattern in practice.
I don't know how they can get this in, but I feel like it needs to be
I
in.
cooperate with the sentence.
Do you want to be heard on 90.8033, then existing mental, emotional, or physical condition?
Judge, his emotional, mental state, that still has to be material to a material fact. And his state of mind at that time is not a material fact. Also, I think the defense is misrepresenting some of what's in the email. Mr. Benefield never said he wanted to buy the house. He said he wanted to rent the house. And he said, I'll have to check with Ashley first. So I think some of the misrepresentation that's going on, we should probably just read the email. But I don't think it has anything to do with his state of mind. His state of mind at this point in time is not relevant.
Well, his state of mind is that he wants to be close to her, even though he's been told he needs to stay away from her.
All right, as I said before,
Which I guess doesn't really matter at this point.
are you going to establish the location of the home through Vizzacaro,
Yes, sir.
where it was
Yes, sir.
in relation to the house where Ms. Benefield lived?
Yes, sir.
And then are you going to then just argue during closing, I would assume?
Yes.
All right, so there's going to be no more witnesses. This is the end of this road to establish
Yes. This is just
witness-wise.
This is an isolated act of DV. Yes.
All right.
Judge, if she didn't actually know about this, then I don't know that it's relevant.
Well, and that's what I was thinking, because, hold on, it's not an act of violence, though.
Right.
Or threat. But under 9803 subsection 3, a statement of the declarant's then existing state of mind, emotion, or physical sensation, including a statement of intent, plan, design,
It is a threat.
when it's offered to prove the declarant's state of mind, emotion, or physical sensation at the time or any other time,
Everything she's doing.
or prove or explain acts of subsequent conduct of the declarant.
Everything. Everyone
Judge,
that
I would
comes
just
and
ask that this
goes.
witness be asked questions if he is allowed to testify. I don't know why we even have to speak about an email. Just, were you helping Doug Benefield and were you looking at a certain house?
I think that would obviate some of the evidentiary concerns I have that you asked if he was assisting him in finding a location. Did you find one?
We'll do
Where was
that.
that location at that you were talking about putting an offer on?
Indeed, and if the court rules against the admissibility of the email, that would be my intention. On behalf of Ms. Benefield, though, I would like to present the best defense that I can. And I think that the email clearly is something the jurors can have, read, see. It's tangible. It has the same kind of impact, Judge, that the prior inconsistent statement of Gillum or the emails involving Stephanie Murphy does. And in the absence of a reason why it should be kept out, I would like to admit it.
All right. Thank you both very much. I'll allow the admission of Defendant's Exhibit 27 under 90.803(6) for the Realtors portion and 9803(3) for the Benefield portion. With the understanding that, again, this is a relatively collateral matter.
In and out, Judge.
All right, can you bring the witness back in, Mr. Vizzacaro? All right, welcome back, sir. Just take your spot back there in that chair. We're going to get the jury back in and begin your testimony.
Sounds good. Thank you.
We'll bring that.
Okay, see you later. Bye.
Gosh,
It's up to you. All right, y'all can have a seat. Welcome back, everybody. Get ready to begin deliberations. Talk with anybody outside the jury about the case or do any research. Everybody say no. Mr. Taylor, you may resume your direct examination.
Thank you, Judge White. Mr. Vizzacaro, when we last broke, you told us you were a realtor and that Douglas Benefield had contacted you relative to a house in Lakewood Ranch.
that's correct.
All right, I'm going to pass to you, Mr. Vizzacaro, what I've had marked as defendant's exhibit number 27. That would be the email messages that you referred to before when we were last in front of the jury, correct?
Correct.
Is that a true and accurate copy of the email exchange between you and Douglas Benefield?
Yes.
What is the date of that exchange?
The last email I see here was March 12th of 2018.
March 12th, 2018. Your Honor, at this time, I would move to introduce that into evidence on behalf of Ms. Benefield.
All right, same objections, overruled. Defendant's Exhibit 27 will be received.
Now, Mr. Vizzacaro, I know you've told us that the home, do you recall the address of the home?
Yes.
What was it?
5060 Newport News Circle.
All right, I'd like, with the court's permission, to dim the lights, and we're going to put a diagram up there for you. And as luck would have it, we have the pointer. Okay, so this will give you
The beam?
Okay. Would you please show us on that diagram where the house was that Mr. Benefield contacted you about purchasing?
This one right here.
Right there. Now, that house, is it directly behind the house in front of it with a red dot on it?
Yes. Yes, it is.
Okay.
Well, there's a little room between them. They're a little bit farther apart than I expected them to be.
Do you know, Mr. Vizzacaro, who was living in the house with the red dot at 11331 White Rock Terrace?
No, I don't.
And do you know whether or not, if I may, you know whether or not you don't know who was living in this house?
No.
This is the house that Mr. Benefield was interested in purchasing.
Correct.
Do you know whether or not Mr. John Sant lived in that house?
I don't know.
Give me just a moment, Your Honor. I don't believe I have anything further. Okay. Should I finish? Mr. Vaccaro, my oversight. I'm going to pass to you what I've marked as defendant's exhibit number 28 and ask you if you can identify it.
Yes, that's the house.
That's the house that Douglas Benefield had contacted you about purchasing.
Correct.
And is that in exhibit 28 a true and accurate reflection of the locale?
Yes,
Does it have a dot on it?
it does.
Does it have an address?
It does.
What is the address?
5060 Newport Circle. Newport New Circle.
On
Excuse me.
behalf of Ms. Benefield, you want to move to introduce that as defendant exhibit 28?
No objection.
Received.
That's all. Thank you very much, Mr. Vizcarro.
Gotcha.
Cross.
So you've had the opportunity to review the email, correct?
Yes, I have.
If I could just grab it real quick. And for the record, this is case exhibit 27. And it appears as though
You're speaking with Mr. Benefield about potentially this house coming up or the price being lowered on this house, correct?
That's correct, yes.
All right. So you were contacting Mr. Benefield.
I reached out to him about that.
Okay. And he actually said he may just want to rent. Isn't that correct?
That is correct.
And he also said he didn't want to do anything without speaking to Ashley first.
That was a comment that was later in the conversation, yes.
Okay.
And if I could show you State's Exhibit 27, it's very small type at the top, so you might be able to.
That's why.
Record defense exhibit.
I'm sorry, Defense Exhibit 27.
Does he say there that he needs to speak with Ashley first?
It appears that way, yes.
Okay.
Yeah.
Thank you, no further questions.
Can you redirect?
No.
Can the witness be released?
Yes, sir.
Ma'am?
Yes.
All right, sir, you're released from your subpoena. You're free to go.
Thank you.
Mr. Taylor, can you state defense, can you approach real quick?
Just because he was going to talk to her first doesn't mean that if she said no, like she could have said no. I don't want you to move right behind me. That doesn't mean that he wasn't going to move right behind her anyway. She has said some things that sound wrong and off and like she shouldn't have said them. Because it makes you sound guilty. But I think that he was
Defense would
very
call, Your Honor,
bad to her.
Dr. Jason Quintel.
Response for affirmative testimony about to give you the truth, the whole truth, and nothing but the truth.
Yes.
Hello, Doctor. Welcome back.
Hi there. Thank you.
As you may recall, my name is Judge White. I'm presiding over the case. Same rules as last time. Just make yourself comfortable. Adjust that microphone as you need. Speak in a loud, clear voice.
Good afternoon, Dr. Kim.
Hi there.
Welcome back.
Thank you.
As a result
say
of the
ask, he
counseling
said speak
sessions
with her.
that you had with
talk to her.
Douglas Benefield, did you reach any conclusions with respect to Doug?
Objection. Improper testimony. Opinion testimony.
You go ahead and approach.
I just noticed on the little banner crawl, it says they were in a heated custody battle. It wasn't that heated if they were moving to Maryland to co-parent. It wasn't that heated. And I think the Google searches on her computer were a good thing. I think she was trying to figure out how to do this in a way that would make everybody happy. Oh, I think we're caught up to live. Yeah, she did say some stupid things like saying to the detective, "I'll do anything to keep my baby." But yeah, as Alita always says, two things can be true at once. She said some stupid things. But just because she said stupid things doesn't mean that he wasn't abusive. And it doesn't mean that there were not times that she was afraid of him. Because throwing a gun and it going off inside the house, and she said he's tripped her, called her names, done all kinds of stuff. And that's the thing with people like that. You just don't ever know what's going to set them off, when it's going to set them off. But then they do have triggers that you do know what's going to set them off. And sometimes it's stuff that nobody else would ever imagine. Like, I was telling my husband, we've been married for almost 17 years now, I think. And I was telling him a story the other night that I guess I had never told him before. Because he was like, "What?" When we lived in Sarasota, I was about maybe 8. And I sang in church one Sunday by myself, solo. And it was a song that I had learned and I'd been singing at home. It was a Christian song. And we went to a Baptist church at the time, and I asked if I could sing it in children's church, and they let me. And I didn't have any music. I just got up there and started singing. And there was this one little girl that started laughing at me. Didn't faze me. I just kept singing. So then after church, Mom came to pick me up from children's church, and the leader of children's church went on and on about my singing and what a good job I'd done, how brave I was, that it didn't even faze me whenever the one kid was mean to me. And, Mom just smiled and shook her head and everything and pretended like I got in trouble. Why did you do that? Did you ask to sing? You should be asking to sing and getting up there in front of people. I mean, like, and my husband was like, oh my God, why? Why'd she get mad at you? I was like, I don't know. So that was the kind of like control. Like, I did something that was out of her control. I stood up in front of people and did something of my own accord that she had no control over. She wanted to take piano lessons. She didn't get piano lessons, so I had to get piano lessons. I hated piano lessons. When I was 5, she put me in ballet. I loved it. I loved to dance. I love performing on a stage. I have been in musicals in community theater and in high school. I love to sing. I love to dance. She took me out of ballet. She put me in piano. She never put me in singing. I love to sing. You should put your kids in what they enjoy, not what you want to live through them. So any way she could control me. Didn't matter what it was. It was something that I wanted to do that was out of her control. She would find some way to control it. And then my first real boyfriend ended up being just as controlling as she was. You know how they say the cycle repeats? The cycle repeats. It really does. And it wasn't on purpose. It's just like you're drawn to that same dynamic in the person. Like, my mom was my best friend. When I was 21 when she died, and I was devastated. And I didn't realize how controlling and abusive that she was until years later. Because when you're in that, I get the minimizing, because there are times when you're in that, you don't even realize that this is how charming they are. They make you feel like it's normal. And they make you feel like if you go against their wishes, that you're betraying them. If you love me, you would do this. And it gets to the point that you actually believe that. Without a doubt, you believe that. So I can see prosecution is right. She wasn't isolated. She wasn't financially dependent on him. But they shared a kid, and he didn't want to break up with her. He wanted to stay with her, and he was not going to leave her alone. And she was trying to do the best that she could. And I think the whole arrest him at the hearing in front of the judge, she should have never said that, because it makes it seem like I want the judge to know what a bad person he is so I can keep custody of my daughter. But what if she did it for protection? Like, what if she really thought that was the only way to get the judge to see what was going on, because the judge wasn't ruling in her favor. She didn't like the judge because the judge hadn't been ruling in her favor, and she thought that maybe that's the only way to get the judge to see what's really going on here. Because he definitely didn't care about that injunction to stay away. And I still want to know what Hazmat said about that package that he sent her, because she started to say, Hazmat told me when she was on the stand, but then that got objected to. So I still want to know what Hazmat said, but I guess we're never going to find that out. Objection, Your Honor. That's bad for my case. I'm looking for a hair tie. I guess I don't have any up here. Any day now.
Okay, Dr. Quintel, so a couple of questions about your practice.
Yes, sir.
I think you told us your specialty was trauma.
Correct.
And for purposes of practicing your profession, various clients come to you and relate their backgrounds, correct?
Various people come to me and they've had traumatic experiences in their background. Some may be upfront in presenting them, some may not. But purpose of treatment is to get now to work better, and sometimes that requires unplugging and healing emotional wounds from the past.
And as part of your art and science, you are trained in picking up and diagnosing various cues in your effort to reach conclusions to try and help them.
I'm not following the question.
As part of your practice, you're trained in being able to observe and detect various cues from these patients, are you not?
What do you mean by cues?
Indications of areas of trouble. For example, you don't always have patients that come out and say, oh, I am traumatized because of this. Rather, they may speak in obtuse terms, and you are charged with, among other things, trying to figure out where the trauma lies and why.
I would answer that slightly different than the way that you're framing the question. So when somebody comes in to see me, my job is to understand what's not working and really what's not working in their life today.
Okay.
If that leads us to unplugging earlier trauma, which frequently it does, great. But that's the purpose when they first come in, is me understanding what's going on with them today that's not working, and hopefully saying it back to them in a way that they're getting it, that I understand.
And in that process, you rely upon various statistical manuals and things that are reflective of your profession, do you not?
I don't do specifically a lot of diagnosing, so I'm not going to use the DSM frequently. I'm going to understand the background of why trauma sticks and how to get that better.
And to understand the background of trauma, have you in the past, or do you periodically consult learned treatises and periodicals, things that help you to reach that understanding?
If you're asking, do I go to continued ongoing training and development? Yes.
All right. Now, in this particular case, did you reach some conclusions about Douglas Benefield?
Objection.
qualifications.
Sustained.
Did you counsel Douglas Benefield?
I did, yes. Both Ashley and Doug.
All right. And in counseling Douglas Benefield, did you listen and absorb the various points that he was making to you?
Yes, both when they came in as a couple and then when I did individual therapy with them separately.
And when they were in there as a couple, was part of your process observing the dynamics between the two of them?
Yeah, I wanted to understand why they were seeing me and what stuff we wanted to get better. So certainly I'm paying attention to what they're telling me, how they're communicating, what they're communicating, and such.
Okay. And part of that included how they acted when they were together and how they acted when you saw them separately.
Yes, I would say so.
Okay. Now, in making those observations and questioning them and listening to them, in your effort to try and identify the objective, did you reach some conclusions about Douglas Benefield?
Objection. Foundation.
Would you approach, please?
I can understand objecting to certain questions, but it seems like the prosecution is having objections to entire witnesses.
A brief deviation, Dr. Pinto. Tell us what degrees you hold.
So I have a bachelor's in psychology, a master's in social work, and a PhD in clinical sexology.
How long have you been practicing as a psychologist?
I got my master's in 98 and started working in the public school system. So since 98, 2006, I started a private practice.
I don't know what YouTube thought that word was. I think it was psychology, but they put an S and then a bunch of asterisks to like bleep it out because they thought it was something bad.
And since you've been in private practice, Dr. Can you give us an idea of the number of patients that you've seen and counseled?
Thousands.
And your specialty in counseling patients runs to all three of those fields that you have degrees in?
Yes, I have a background in all of that, but my specialty is in trauma resolution.
Okay. And when we speak of trauma resolution, explain to us what that is.
So I think the first thing that somebody has to understand is trauma, or what we go through, isn't troubling because it happened, which is the conventional wisdom, is that because it was awful, it still hurts. But we're not troubled because it was bad. We're troubled because when it happened, emotionally, the brain short-circuited and doesn't know that particular experience ever ended. So where therapy missed the boat is we felt that people buried and repressed, and we have to help them process and get it out of them. Where the methodology that I use is the reverse. It's about getting the good news in to the emotional part of the brain that doesn't know it's over. Think of it more like unplugging the memory, so emotionally the brain can read it as data about something that happened versus where it's been stuck as happening, which explains why when somebody frequently either talks about it, is reminded of it, or is in something similar to it, emotionally they're transported back to that awful moment, right? If you have a friend telling you about something that was troubling them, and as they're telling you about it, it's almost as if they go back there to that troubling moment.
Mhm.
So our goal is to keep the person more emotionally present as we unplug the emotional effect that the past has had.
And in that process, do you typically employ listening to patients?
Yes.
Do you typically employ making suggestions to patients?
I don't know if I would say it's making suggestions versus more kind of having a mutual outcome of how we want them to be in mind. So if I'm kind of creating a future self or an outcome, it's got to be something that they're good with, or if it shows up as conflictual, we're never going to be able to reach the outcome.
Okay. Now,
So more instead of a suggestion, it's more of kind of a mutual outcome.
all right, and you went through this process with both Doug and Ashley Benefield.
I did, yes.
Your Honor, I would tender Dr. Quintel as an expert in the field of psychology.
Do you want to voir dire the witness?
Objection.
Do you want to voir dire the witness as to experience, training, and knowledge?
Yes.
All right.
You do most of your work now in trauma resolution, correct?
I do, yes.
Okay. And how long have you done trauma resolution?
Since 2006, October.
So for many years. And you said you don't do diagnoses anymore, correct?
Yeah, I don't look at diagnoses with people. I look at people because the notion of the diagnosis will help in understanding maybe some of the background of why somebody acts, but you're really working with the person. So if somebody says to me, do you treat OCD or, bipolar? I would say I work with people, not the disorder.
Okay. So when you're dealing with, for instance, Doug and Ashley Benefield, you're not doing so in order to create a diagnosis or evaluate. I guess what I'm trying to get at is there's a difference between therapy and a diagnostic evaluation.
Yes, ma'am.
Okay. And so your relationship with them was what?
They were referred to me by another therapist, and my job was to do trauma resolution. What I was told is that both had their own trauma, and there was some stuff within the relationship, and that I was tasked with unplugging the emotional effect of those experiences.
Okay. Thank you for the question.
You may resume your question.
So in treating people, not the disorder, you still, though, do you not have the capacity and the training and experience to understand if a disorder is present?
Yes, sir.
At this point, Your Honor, I would now tender Dr. Quintel as an expert.
And I
You
would
already heard
object.
any- Same objections?
Same objection.
All right, I will rule the objections goes to weight, not admissibility. Go ahead, sir.
Thank you. So, Dr. Quintel, all right, we're rolling.
Okay.
Did you reach any conclusions with respect to Douglas Benefield?
Yes.
Would you tell us what those were?
Based on the conversations with both Ashley and Doug, Doug occurred as someone who was domineering, and the terminology that I would use at times would be super controlling. He was very dedicated to wanting the relationship to work. He was very interested, despite conversations with some of the disparaging things that Ashley had said to him. He was very much still wanting this to work, and their plans were to move to Maryland.
All right. Did you reach any conclusion?
How much should good car insurance cost you a month?
Oh,
$80? $120? Nope. Try $38.
Did you
Sorry.
conclude whether there was an intimidation issue present?
Ashley stated that she was scared of Doug.
Did you reach any conclusion, Dr. Quintel, about whether Doug's depiction of himself as being godly was reliable?
Objection outside of expertise.
Oh,
You can answer.
Can you say that again, please?
Sure. Did you reach any conclusion with respect to Doug's presentation of himself as being particularly godly?
Yes, I think it was over the top.
All right, and did you reach any conclusion as to whether it was genuine?
I did not think it was fully genuine, no.
godly as in religious or as in he was godlike? That was a confusing question.
Did there come a time when you inquired of Doug why he would want to remain in this relationship?
Yes, I did.
Why did you do that?
Ashley had a lot of disparaging comments, stuff with CPS, claims of abusing their child. And I was concerned and curious why, with all of that negative stuff that may even negative affect his job and career with government, why he wanted to stay.
And was it true that you felt he was hell-bent on being together?
I know that he really wanted the relationship to work.
Did you conclude that he was never going to let her get away?
I don't know whether that's true, whether or not. I don't recall that.
All right, let me pass this to you and see
Please.
if it refreshes your recollection, if I may.
Thank you.
Does that refresh your recollection, Dr. Quintel, as to Doug's perception of letting Ashley get away from him?
Yes, I said that to the detective. I said it seemed more like I'm not going to let her get away from me.
Referring to Doug.
Yes, sir.
All right, and lastly, Dr. Quintel, did Ashley have anything to say to you about Doug's interest in Emerson and whether or not it was just as
Objection, hearsay.
sustained.
Did you reach any conclusions, Dr. Quintel, about Doug's interest in the child as opposed to Ashley?
Objection, Judge.
I'm going to sustain this to the opinion.
Was there an incident on one of these occasions when Doug was in your office that you thought was very strange as it related to the child?
objection, relevance.
Overruled as long as it's factual.
Yes.
Can you say that question again, please? Thank you.
Was there an incident that you observed that you found particularly puzzling between Doug Benefield and the child, Emerson?
Yes, at the time that I spoke with the detective, I had an appointment and Doug had waited in the reception area, and it was a couples counseling, and Ashley was out in the car with the child. And I thought it was unusual that he didn't go out and see her. Given that they had the relationship they had, it may not be as unusual as I thought, but I was coming from having two little girls and what would be in my mind to do.
And how long was Doug sitting in your office at the time? Do you recall?
Well, it would have been at least an hour. I don't know how long I was in the appointment before.
And in that hour, from what you observed, with Emerson, the child, outside in the car, Doug Benefield never once went out to say.
I wouldn't have been able to observe that because I would have been in session. I just knew that he was waiting in the lobby. I don't know whether anything other than that.
That's all, Your Honor.
Cross.
So you mentioned that it bothered you, or at least you noticed when he didn't go out to see the child. How long did you observe Doug Benefield in the waiting room?
I would have seen him when I first went out to grab the client, and then would have seen him when I came back out of my office.
And because of that, you came to the conclusion that he never went out and saw his child?
Yes, I did.
Okay. And I believe, and correct me if I'm wrong, in your direct examination, you said you met with Ashley Benefield alone 5 times.
Well, he doesn't know that he didn't go out to see her if he was in there with another patient.
Yes, ma'am.
And you met with Doug Benefield alone twice.
Yes, ma'am.
And you met with them together twice.
Yes, ma'am.
So the majority of the time you met with Ashley Benefield. Over half of the times you met with her.
To do trauma resolution. Yes, ma'am.
And her discussions with you and her recitations of things played into your decision about this opinion that Doug was being domineering and super controlling, did it not?
Yes, they were comments that she made and frustrations that she had within the system.
Okay. So it was not solely based on things that you were observing in Doug Benefield.
No, ma'am.
Thank you. No further questions.
Redirect.
Nothing further.
Can this witness be released?
Yes.
State.
Yes.
All right, sir, you're releasing your subpoena. Thank you very much. Here you go.
Thank you.
He's happy.
We published a couple of exhibits that we put in through this week as a Carl.
You didn't miss much because of sidebars. No,
That's not, yeah. So you have 27?
he asked a question, prosecution objected, then they went up to sidebar, and then when they came back, they started asking questions
And then one we added.
about education and stuff, basically so they could make him an
Yes, so
expert
here's the jury.
witness.
We're gonna pass these out and publish them. I'm not rushing you, but I'm gonna talk while we're doing that. I think at this point, it's a good time for our lunch break. It's about 10 minutes after 12. So take your time. I want you to look through all of this, look through these exhibits, and then I'll excuse you.
Exhibits 26 and 27.
Those 27 and 28, and they'll be marked on them. There's a little sticker on each. Which should say 27, 28, and I think the other one is Defense Exhibit 1.
When did you leave? When when they were talking about the email from the realtor? So what happened with the realtor was he asked about moving into the house behind her. They put up a picture, and it wasn't as close. They didn't get the email in, but they did ask the realtor questions. What are they waiting for? I thought he just said they were going to lunch. So they asked the realtor questions about him wanting to move in the house behind Ashley. I had said that the houses were like a stone's throw from each other because where I lived in Sarasota, that's the way the houses were. But it looked like the houses were, instead of like straight rows, it looked like the houses behind, like he wanted to move in the house on like this corner, and her house was on this corner. But the houses on her street, the street curved away, but they were on the corner, so they were back to back, but they weren't as close as I thought that they would have been. But still, they were close. They were still close. But so his road would have been straight, and the other road that she lived on would have curved. But yeah, still close because they were on the corner. They were corner houses, so they were still close. And he had told the realtor, when the cross exam came up, they found out that he told the realtor that he was considering buying, but maybe just renting it, and that he would need to speak to Ashley about it first. Now, because he told him that doesn't mean he was going to do it. And he said, speak to Ashley or talk to Ashley. He didn't say ask Ashley. But either way, that doesn't mean he did actually ask her, or that even if he did talk to her, that he respected her wishes. He might have just thrown that in there so the realtor would think everything was on the up and up. And how do we even know that the realtor knew anything about the injunction? So that was all that was. And then after that was Dr. Quintel again. And basically, all he said, well, Taylor asked a couple of questions, and then the prosecution objected. So they went up to sidebar. Then when they came back, he was asking him questions off his CV, like how many degrees he had and stuff like that. So then he asked for him to be designated as an expert. Prosecution objected, so they did a little voir dire, and so he was said to be an expert. And he said his conclusion of Doug was that he was domineering, super controlling, and that he was extra interested in Ashley, and that he wanted the relationship to work. And that Ashley was scared of Doug. And that he wanted to know why Doug wanted to stay because of the claims of child abuse against the child. Like,
so it's 12:15.
Ashley.
If I could have you back down to the jury assembly room where you began everything this morning and last week at 1:30. Should give you plenty of time if you want to go somewhere, if you just want to walk downtown. Be in the jury assembly room at 1:30. We'll get you back up here as soon as we can to get started for the afternoon. Remember the admonishments: don't talk amongst yourselves with anyone outside of the jury. We're doing any research on the people, places, things, the legal topics we've heard anything about. Thank you.
So yeah, they didn't let the email in.
All right, y'all can have a seat. I would assume, before I let you all go, that the request for an exhibit list from the defense of the items that they expect to introduce has been provided,
Yes.
and certainly a list of witnesses that are expected to be called.
Yes.
I didn't get a copy of that. If it's been amended from the witness list that I received, it looks like it was filed June 21st of 2024. So I'll just mark, but who do we have on tap for this afternoon?
So we
I don't need to
have-
know the order, but just who?
We have Jason Alexander, Michael Haig, Haag, Dr.
Hold
Emma
on one second. I'm sorry. I got, my list is, okay. Michael Haig,
Michael Haig, Dr. Emma Lou,
all right.
and Warren Justin.
Warren,
Justin, the lead homicide detective.
all right. When we, and none of these, have all these folks been deposed?
Yes.
All right. Are there any objections or anything I need to hear before, before we get a jury in and get them seated and make them sit there for 5 or 10 minutes while I hear arguments at the bench? I would much, much rather
Yeah, me
have the
too.
objection made. Let's talk about it, and then let's call the jury in so it's a little bit smoother.
With Detective Warren, I may have objections, but I don't know what's going to be asked. So without asking what they're going to ask, I don't think we can have that conversation. And additionally, if Detective Gillum is set to testify, I would have similar objections.
You didn't say that name.
No, they've been keeping him here, so. I
Okay.
guess-
You think just 1, 2, 3, 4 witnesses are going to take us the whole afternoon?
Yes, I think there's a reasonably good chance we rest today.
Okay.
Ooh.
Oh, is this the bulk of what you're calling at this point?
Yes, sir.
Okay. Well, that would be fine, because then we could do a preliminary charge instruction this evening. Then you guys can decide if you want to do any rebuttal. Okay.
So the one request I do have, Your Honor, is for Mike Haig, who's our ballistics expert.
Mike,
We needed
Mike
Haig,
Haig, yes.
Haag.
Okay.
We need the HDMI cable to run to the witness stand so he can put his laptop.
To where? Here? I don't understand.
More.
Project
Okay,
it.
yes, yes.
So it'll be up on the projector.
So he's going to use his laptop to
Demonstrate
project here.
his testimony, yes, sir.
I know this is the one we used. I don't know, Deputy, does that stretch to here?
We'll inquire and we'll check it out.
Oh, you know what? IT has got to come and fix my computer anyway. So can you tell them that we also need,
HDMI.
that a witness this afternoon is going to have to run to that?
Yes, sir.
Thank you so much. And then that'll take care of both, because my goblins, just, you know how it goes.
Okay,
All right.
thank you, Judge.
I guess the only other questions they would have is there were other witnesses that were held by the defense. If these are the remainder of their witnesses, are those witnesses being released? Because they're asking the state. for this.
We don't know what they're presenting in
Yeah.
rebuttal.
Okay.
I don't know. My thing, I've been thinking about this all weekend. Like, when she testified, I believed her. And I believe, like, I know the fear. I know the cycle of abuse. I know the fear. And I know wanting to please the abuser. And I know the honeymoon period that happens. Like, I get that. So I think she was abused. Of course, nobody was there when he was shot. And she has said some sketchy things, some very dumb things that she shouldn't have said, like arrest him in front of the judge at our next hearing. I'll do anything to keep my baby. So she's made some stupid comments. So, yes, I think she was abused. But what if she is lying? See, this is why I couldn't be on a jury. Because I second guess myself all the time. Like, I can see it from both sides. This could be all an act, but it could be true. And like in my head right now, I'm going, what if I am falling for her story? What if this is all made up? But at the same time, I can see how it could be true. So right now, I'm kind of confused. But at this very moment, if I had to, if right now I had to choose, I would choose not guilty. Just because I would hate if it had actually happened and she went to prison. I couldn't do it. That's true. I guess I do have reasonable doubt. And we've also been given proof that he abused his first wife. And that doesn't change. Abuser's gonna abuse. That doesn't change. Okay, so he's said to be back at 1:30. I'm trying to decide if I want to go get something to eat or if I want to make something at home. So, do you guys want to start at 1:30? And we'll have lots of dead air when we do sidebars? Or do you want me to start like later around 2? Because we started like 45 minutes late this morning and we still caught up to live. Okay, 1:30. All right, guys, I will see you then. Bye. Have a nice lunch. Okay, 1:30.